Lori Vallow has filed several motions over the past week or so ahead of the trial. One is the motion to preclude evidence of phone data and text messages. Also, a motion to suppress evidence pertaining to the Jeep Wrangler, and a motion to dismiss for non preservation of crucial evidence. What do all these mean? I've got the documents here, requested them all from the clerk, and we're going to go through them one by one and explain to you a little bit about what this will mean, if anything, for the trial, along with Treena Kay, the prosecutor's responses. So let's jump right in. The first one, the motion to preclude or exclude evidence of phone data and text messages. Lori says, she wrote this all handwritten. I don't know if you can see it here, but she wrote this from her jail cell. The defendant, Vallow Daybell, requests this court preclude all evidence of phone data and text messages relating to Alex Cox. The alleged conspirator is deceased. Therefore, the state cannot establish Alex Cox's intent, knowledge, or absence of mistake. Facts. She says telephone messages are inadmissible, and she quotes some other case law. There's some case law, but I don't know if she establishes what that is. She says the federal wiretap, state invasion of privacy, prohibits unlawful access to stored electronic and communications. She says that the data was illegally obtained, and according to Riley v. California, it is hearsay anyway. Also, if the state is using geofencing from Google or location history directly from the account, the state still cannot determine who was in control over that device at that time. So any data obtained would be pure speculation as to the actual person's location. Lori says a phone is a small device that could be picked up by any person and transported by any person. The state has made no determination, underlined, to the defense about any data turned over to the defense regarding Alex Cox is actually data from Alex Cox. Any person who knows your email address could purchase a phone and attach your email address to it. The defense requests this court preclude all evidence of phone data regarding Alex Cox in this trial for all of the reasons stated above. Signed, Lori Vallow. Okay, I think what I'll do is I'll jump back and forth between what Lori filed and what the prosecutor responded, how the prosecutor responded, so that I'm not giving you all of the data or all of Lori's filings right up front. Okay, so what she says, this is how Treena Kay responded to Lori's request to have all of the data and text messages thrown out. Treena says the state of Arizona requests this court deny the defendant's motion to preclude text messages, iCloud data, cell phone data, and Homer J. Maximus Gmail location data. This evidence and data were obtained pursuant to search warrants, and text messages are admissible pursuant to Arizona rules as statements of a party opponent. On October 10th, 2019, Gilbert Police obtained a search warrant for Verizon phone number. On December 3rd, Gilbert Police obtained a warrant for Verizon, another number. And on February 26th, all of the evidence the defendant seeks to preclude was lawfully obtained through multiple search warrants. So short, to the point response right there. The defense says, kick it out, don't let it in. The prosecution says, we obtained it all legally. It has to be let in. I do think that this is going to be let in because it was admitted in the other trial, in Charles Vallow's trial with the same judge. But we'll see. We'll see what he has to say. Okay, let's go to the second motion from Lori Vallow, which was the motion to suppress evidence related to the Jeep Wrangler. This is the Jeep that belonged to Charles Vallow, that was used when Brandon was shot at, and that Alex Cox did the shooting from. Lori says, pursuant to the Fourth Amendment, the defendant requests the court suppress all evidence obtained as a result of illegal, unconstitutional, warrantless seizure of the Jeep Wrangler. On or about October 17th, 2024, approximately 7 months ago, so last October, Detective Ray Hermosillo of the Rexburg Police Department was interviewed on a podcast entitled Facts Me That Podcast. During this 2-hour, 12-minute interview featuring Detective Hermosillo, the detective informs the public how he obtained the Jeep Wrangler on November 4th, 2019. Detective Hermosillo indicates at about 5 minutes in that, number one, on Monday morning, November 4th, 2019, while driving home from the gym, he spots the Jeep in an apartment complex parking lot. Number two, he makes some phone calls and gets the Jeep impounded. Number three, he then goes on the phone with Arizona and states, quote, "I got your Jeep." Number four, Arizona says, quote, "Hang tight, we have to get a warrant issued." Number five, Detective Hermosillo then states, quote, "That Jeep sat in our custody a week and a half till they showed up." Conclusion from Lori. So after seizing the Jeep Wrangler without a warrant, Detective Hermosillo then took steps to obtain a warrant. The defense requests all evidence obtained as a result of this unconstitutional warrantless seizure in violation of the Fourth Amendment be suppressed. A suppression hearing is requested. Now, this is how the state responded to Lori's request and the allegations about Detective Hermosillo. On November 1, 2019, Detective Hermosillo with the Rexburg Police spoke with Detective Nolan McDermott from Gilbert Police. Detective McDermott sent a probable cause statement to Detective Hermosillo, providing probable cause to seize the 2018 Jeep Wrangler with license plate number and VIN number such and such. Detective Hermosillo went to court on November 1 and obtained a search warrant. Detective Hermosillo documented that he obtained a search warrant for the Jeep on November 1 in his police report. The state obtained a search warrant, a copy of it, and disclosed that to the defendant. So Lori has the warrant. On November 4th, so 3 days later, Detective Hermosillo observed the Wrangler on Pioneer Road in Rexburg. Detective Hermosillo had probable cause from Gilbert Police that the Jeep was used in a shooting in Gilbert. He knew that the Jeep was movable and could be driven away, and he had lawful authority to seize the Jeep pursuant to the search warrant he obtained on November 1, 4 days earlier. Detective Hermosillo documented in his police report that he seized the Jeep on November 4th and had it towed to the RPD. Upon seizing the Jeep, Detective Hermosillo realized his original warrant contained the correct VIN number, but there was a typographical error as to the year. It indicated that it was a 2008 instead of a 2018. Detective Hermosillo immediately obtained another search warrant for the Wrangler with the correct year, fixing the typo, and a copy of the search warrant was given to the defendant on February 26th, 2024. Last year, I want to be sure that I got that year right. Yeah, last year, over a year ago. Although Detective Hermosillo could have lawfully seized the Jeep Wrangler based upon probable cause by the Gilbert Police, he did in fact seize the Jeep Wrangler pursuant to a search warrant that he obtained on November 1, 3 days before the seizure of the Jeep. The Jeep was lawfully seized. The state requests the court deny the defendant's motion to suppress all evidence pertaining to the Jeep Wrangler. So that is their response to that one. The final thing that Lori Vallow, the motion to dismiss for non-preservation of crucial evidence. She said that the state of Arizona did not preserve the crucial evidence of, quote, the car door or, quote, the car window of the alleged victim. It is a violation of the 6th and 14th Amendment of the United States and the defendant's right to due process. The lack of preservation of this crucial evidence is prejudicial to this defendant and her defense team. The defense has requested the state of Arizona the actual door of the car that was allegedly shot and the window of the car door that shattered as a result of the alleged gunshot. The defense was informed by the state that they do not have and did not preserve the car door or the window. Therefore, they are not available to the defense to do their own independent investigation of these two crucial pieces of evidence to this case. There are nothing but pictures of the car door and the car window. Therefore, the defense and its experts cannot measure or test anything about the alleged shooting. This is a violation of the state, precluding this defense from doing an independent investigation. And then she asks the judge to dismiss the case. Well, Treena Kay filed a response. And this is what Miss Kay said. She said that the police department did not act in bad faith when they decided not to preserve the Tesla or the Tesla's driver's side window or any testing or window because this would not exonerate the defendant against actions she took in Rexburg to aid in the charge of conspiracy to commit first-degree murder of Brandon Boudreaux. And the prosecutor lays out the timeline very well in this. So I'll fast forward a bit and then I'll come back to this. But basically, what Treena Kay says is that the defendant has police reports showing that the Gilbert Police did not impound the Tesla since December 12th of 2023. The defendant has failed to show any bad faith on the part of the Gilbert Police in their decision not to impound it. She hasn't listed reasons why what they did was bad. And the Gilbert police failed to preserve it because it has extremely limited evidentiary value and no value to exonerate the defendant's actions that were occurring in another state. So Treena Kay is saying, regardless of whether we had this car, regardless of what happened to the window, it doesn't talk about what Lori was doing in another state, Idaho. Lori didn't pull the trigger, and she's charged with conspiracy to commit this murder. So had they saved the car, ultimately, how is that going to come into play is what Treena Kay is saying. And we're going to show you what Lori was doing in Idaho while this shooting took place. So those are the 3 motions that were filed. And of course, the 3 responses from Treena Kay asking the judge to dismiss each one.